one of the delegates, I think it's from Pumalanga somewhere. I said, hey, comrade, we have to start the conference. He asked me, what conference? He said, no, we still have a program. He said, as soon as I elected my top 6, the conference was finished and I'm leaving. I think that's the problem we are having today. Once delegates elected, they just say, no, that's the end. And I'm not too sure, there's this popular word of top 6. It seems to be everywhere. Everywhere there are people, there's some form of a top 6. Yeah. We have our deputy, we have a new deputy president, Justice Mahlanga. He's fresh from the box. Some of them, when you look, they are almost, you have seen, but the deputy president is really fresh from the box. DP, because we are not here yesterday, you were elected in absentia. Yeah. Thank you very much. He was not He was not here yesterday because he had to rush to a meeting of the legal aid in Johannesburg. There were some awards. He was being awarded. And one thing about our deputy president is that he appears in court. Recently, in a case that we're watching on television, his client was granted 174. He's not one of those losing lawyers somewhere from Mthatha. I saw from some WhatsApp, from Facebook, but hey, if you want to lose a case, go to no case. That one is a losing lawyer. So at least we have a balance now. We have a winning lawyer and a losing lawyer. Firstly, I'm sorry that we're starting late because of these things. Secondly, Mr. Pityana will not be with us. That item will be cancelled. He cancelled at the last moment. He sent me what you call? He sent me an SMS to say that he has been close to somebody who was tested. And then it was not easy for him to join us. So what is going to happen, we are going to go straight to the CEO of the LPC, who will talk to us on the LPC. Broad and also response to some of the issues that were raised yesterday about the LPC, and then we'll talk about that. Just general what they do about the LPC, there at the LPC offices, all the things that were there. She will tell you and highlight key things. And then after her, it's not him. After her, we will go back to the financial report. And then after that financial report, then there is a resolutions committee that was appointed. I'm not too sure where's my SG. Where is that committee? That resolutions committee. And who were they? Yeah, there was a resolutions committee. That resolutions committee will deal with its matter when we hear the financial report after charity. And then we will be done. Then we'll explain later the further processes. So let me quickly ask the CEO of the LPC to come and address us. Because SG, because you are the employer that side, I want you to preside over this session, and also please briefly tell the conference about the CEO of the LPC. I'm happy that Mr. Jordan has joined us in the conference. Where is he? Oh, also, Justice Madlala, I will quickly tell about these people. The Deputy Secretary of the organization is brand new. It's a new Mercedes, very fresh. There is Advocate Brown. This is this. You know, one of the things, she appears in court. This thing that we are going to have litigation is real, because we have made sure that lawyers are there, people who go to court. She is appearing in court, so she understands what, and she has appeared. Have you appeared in the Constitutional Court? She has appeared in the Constitutional Court, and you won that case, is it not so? The independent candidate that were contested, about how many this time, were about 380, but there were many, and they have won in the majority, thanks to our Deputy Secretary here. Yeah, we hand over to you, the Deputy.
Thank you, President. Your Deputy Secretary is very short. Okay. Welcome, everybody, to the session, our first session of this morning. And I think this is going to be a very interesting topic, because the Legal Practice Council is our new mother and father body of our organization. So I have the privilege of introducing the guest speaker, Ms. Charity Nzuza, who is currently the Executive Officer of the Legal Practice Council. Now, she has a very long history, and she wanted me to inform you that she is from KZN. She's originally from KZN, born and bred, and she spent most of her life in the private sector. She was at Unilever, and then she went on to a company called BHP Billiton. After that, she then decided private sector was no longer for her, and she joined the public sector. She started off as the Chief Director of the Legislative Costing at the Department of Justice and Constitutional Development. She thereafter went on to become the Executive Officer of the National Forum. She spent a few years at the National Forum so that we could transition into where we are now in the Legal Practice Council and have with the Legal Practice Act. And she is currently the Chief Executive Officer of the Legal Practice Council. So you know, when you send those important emails to the Legal Practice Council, Charity is the one that responds or that deals with it. And the topic today is in conversation with the LPC. So without further ado, I'm going to call on our guest speaker to have a conversation with you.
Thank you very much, Ms. Brown. As I've been introduced, my name is Charity Nzuza. I would like to say good morning to the judges that are here today. Good morning to my chairperson of council, which is Ms. Janine Maybeck, and my EXCO member was here today, Mr. Mabunda, and another member of council, Ms. Nolita Chali. I'm not sure if Krish Govender is in today, but he's my previous council member. And with me, I've brought the director of the Eastern Cape office, which is Alfred Horner. And I hope that most of you know him. When I was asked to talk about the Legal Practice Council, I thought there's so much to talk about, but I will try to summarize some of the things that I think you ought to know, and maybe give you more time to ask me questions if you feel that there are things that you want me to clarify. Just in the 3 years that we've been in operation, we came into existence on the 1st of November 2018. I've noted that legal practitioners possibly maybe have not read the Act, the regulations and the rules in its entirety. And I urge you to have this book, because this is the Bible of the legal profession. This is the Bible that we use to regulate counsel, to regulate you as legal practitioners, and that we use to protect members of the public. And I wish to reiterate to you LPs sitting here today that I see my role as dual. The Act requires that I protect the members of the public, but I also know that I need to protect you as legal practitioners and ensure that your interests are taken care of and you are able to practice without fear or any favor. Right. So the first thing that I will want to talk about in terms of regulation, and I'm going to start from the top and go down towards the end on how we regulate the profession. The first thing that I will want to talk about is the issue of practical vocational training. Now we have a problem here, legal practitioners. Our students who pass LLB do not get articles. And that is because you don't give them articles. You don't hire them and train them for the 2 years if they want to become attorneys, or for the 12 months if they want to become advocates. There is a shortage of principals to train these people, and we find that LLB graduates are sitting at home, and some of them will possibly choose to go and do the legal training, which is 6 months, because there is no principal who's willing to take them. So my first request to you this morning is to open your law firms up and take up and engage LLB students and train them to become either attorneys or advocates, because the role of the legal practice council is to ensure that there is access to the profession, and I cannot do that without you. Just speaking more on the PVT contracts that we need to enter, something that I feel that most of you or the candidates themselves are not aware of is that when you enter into a contract with the principal, you need to make sure that you lodge that contract within 2 months of it having taken place, so that it is then registered as per the time you started working for that principal. If you don't lodge it within 2 months, then you miss out on the time from the time that you actually started working there, which has been a big problem with us and the candidate attorneys or pupils. They delay lodging those contracts. They are unable to write the exams because there is a requirement that for you to be able to sit for the competency-based exams, you need to have started training with the principal for a period of 6 months or more. So I urge you, LPs, that when you enter into these contracts, you alert your candidate attorneys or your pupils to go and file those contracts with the LPC, and you will know that we have an LPC office in every province. So there is no need for you to drive hundreds of kilometers to lodge those contracts. I'm reiterating this because this has been the major issue, where the contracts are lodged very late, and then you find that when you want to go write the exams, we will not be able to accept you because you have not finished the 6 months that is required. Also in terms of engaging, because this is the part that I want to stress the most, please engage LLB students, train them. If you are a law firm, you are allowed a maximum of 3 candidate attorneys, but legal aid is allowed 6, and I think they take up most of the candidate attorneys. Advocates are only allowed one pupil unless, of course, they are a legal aid advocate. So just make sure that you do engage your candidates as per the numbers that are put in the Act or in the regulations. Then the second item that I wanted to speak to you about is the competency-based exams. We have put up the dates for next year, for example. They are already up. They've been sent to all the LPs. You can share it with your candidates so that they know when they are supposed to write. We will publicize the date of registration, and registration happens online. Now, we also have problems in this part of our regulation because the Act is clear and the rules. You are only allowed to write the competency-based exams only after you've been training for 6 months or more. You can't write earlier. And if you are writing for the first time, you are registering for the first time, you need to register for all 4 exams. If you are an attorney, advocates, I think there's 5 exams. Yes, I think there's 5 for advocates. But one thing that has come with the LPA or with the LPC is that if you fail 1 or more exams, you are allowed to write only that paper that you've failed within a period of 3 years. So it gives you time to ensure that you pass all the 4 exam papers, or the 5 if you are a pupil. The third item that I want to speak about is admission and enrollment. Admission being governed by Section 24 of the LPA. I'm not going to go into much detail on that, it's on the Act. But what is important is that when you are admitted, it is your duty to enroll with the LPC. Just to be admitted does not complete the whole process. You need to be admitted and enrolled. And enrolled means that you serve your admission papers at the LPC, and then we must put you on the roll of either attorneys or advocates. After that, you are free to practice anywhere in South Africa. You are no longer bound by practicing in a particular province or in a particular city. The role is a national role, and you can practice anywhere in South Africa. The next item that I thought I could speak about is the right of appearance. I know this is a bit of a problematic area, but there are rules that govern the right of appearance. When you register your contract, you will get your right of appearance from us, and you'll be able to appear in the district courts or lower courts. I'm not a lawyer, so in case I get the courts incorrectly, please excuse me. But you cannot appear in the High Court, the SCA, or the CC. Now, after a period of 3 years after admission as an attorney, you will then serve your papers, and the registrar of the High Court will then give you right of appearance in the High Court. But for advocates, yes, we know that there's a difference there, because after admission, they do get right of appearance in the High Court. And the main difference there, which we are trying to resolve, is the fact that pupils in their 12 months training do a lot of trial advocacy training, which is not done by attorneys. So that is the difference. But we have picked up that this is an issue, and the chair would have said to you that we have amended rules, amended regulations which are before the portfolio committee, where we seek to standardize the training for both attorneys and advocates, so that the difference only comes at admission. If Parliament can pass and the minister can pass those amendments, then everyone will receive the same training, but then only at admission they will decide whether they want to practice as an attorney or an advocate. I hope that I've answered that question of the difference. It is because of the current regulations, and those regulations can only change by the minister, not by the LPC. But we have requested an amendment. Another important issue that we are facing is legal practitioners practicing without a valid FFC. The FFC period is open. It was open from the 1st of October. And the Act is very specific. You need to have that FFC for the following year in your possessions by 31st December of the previous year. And it is a misconduct to practice without an FFC. And this is the biggest problem that we have. LPs are practicing without an FFC, and then we have to then bring in applications to either suspend them or interdict them. So this is the biggest problem that we are having. If LPs are practicing without an FFC, there is no cover for that LP with the Fidelity Fund. And it causes us problems because now members of the public are exposed. So I urge you to please apply for your FFCs before the 31st of December. We ensure that our offices have all the employees or the officials that will assist you if you have problems with your application process. Right, and then the next item that I thought I could speak about is the handling of trust accounts and the duty to account. The Act is clear. If monies are deposited into the trust account, they belong to the clients. They are not funds of the LP, and they must remain in that account until the work is done, and they must be accounted for, and the full reconciliation provided to the client. At the end of your accounting period, you need to provide us with an audited financial report, and if it's unqualified, you will be eligible to apply for the FFC for the following year, and also you can apply for the refund of your audit fees for that period. It is your duty to apply for the refund if your audit report is unqualified. The next item is good standing by legal practitioners. Most of the legal practitioners are not in good standing. It's a bit of a problem. And Section 1 and Rule 120 actually tells you in detail what is good standing. You need to, firstly, if you are practicing for your own account, to have an unqualified audit report. You need to have paid all the subscriptions and the money is due to council. You will note that council in the past 3 years has not increased subscriptions. They've remained at 4,025 rands for those practicing for 2 years and more, and they are 1,725 for those practicing for 2 years and less. We have kept them the same, but again, subscriptions are dependent on what we receive from the Fidelity Fund in the form of an appropriation. So as much as we want to keep the subscriptions the same and not change it, we are dependent on what the Fidelity Fund gives to us as an appropriation to be able to balance our books and be able to serve the legal practitioners throughout the 9 provinces. So I urge you to please pay your subscriptions. We have almost 40% of legal practitioners not paying their subscriptions, and we do offer terms of payment. If you feel that you cannot afford the 4,025 once off, you are allowed to call your provincial office and make arrangements to pay over 3 months. But remember, if you have an arrangement of paying over 3 months, you are not in good standing until you have you've paid up the full annual levy for that year. It is your duty to pay the annual levy, and it is in the Act and the rules. And you just cannot practice without paying it. We have had a lot of issues with legal practitioners abandoning their practices. It's not allowed that you abandon your practice. You need to advise your provincial council if you are no longer able to carry on with your law firm, so that you can do all the requirements of closing that law firm. You cannot just abandon it and leave your clients hanging. You need to account for whatever was in the trust account. So everything is set out in the Rule 54, which sets out what you need to do if you want to close your law firm. I urge legal practitioners not to abandon their law firms, because then we will have to then do a disciplinary process and then apply for your strike off or suspension. And that is something we don't want to do. We really want to work with you so that if you are unable to carry on with your practice, you let us know, and then 2-3 years down the line, you are still in good standing and you are able to come back and open a practice. So it is just you working with us and ensure that you comply with the requirements of the Act and the rules. Then the last item that I want to speak about is the disciplinary processes that we have to undertake as council. One of the speakers yesterday, I think it was Advocate Mpofu, who said the disciplinary process at the LPC is very long. At the statistics which we had available in end of October this year is that we have 14,000 active cases or complaints against you as legal practitioners. 14,000. And we only have 300 staff members. So there is a problem that there are complaints that come to us every day. And when we receive a complaint, we don't take it immediately that you are guilty. We have to then give you a right of reply so that we understand what is the complaint based on. Some of the complaints do not have merit, but some of the complaints then have to be referred to an IC, which is an investigating committee, and then further to the disciplinary committee. The Act requires that we do that. We cannot shortcut the disciplinary process because we have to protect both yourselves and the member of the public. So you will just look at it yourself. If we've got 14,000 cases that are open, we have to send you the complaint. We have to wait for you to respond. We give you 30 days to respond because some of the matters that people are complaining to you about are not recent matters. Maybe it's a matter that you dealt with 3 years ago. We must give you 30 days for you to go pull up that file and be able to respond to us properly. So it will not be a smooth and quick process because we want to ensure that we deal with the matter appropriately and we have all the facts. If the matter then moves to a disciplinary committee, we then have to present all the facts for the DC to make its recommendation. But you will remember that if the disciplinary committee recommends a strike-off, only a full National Council will authorize that strike-off. They will go through the papers before them, the recommendations of the DC in the province, and only the National Council is able to approve the strike-off. So it is a long process, and which we try by all means to make sure that everyone is given a right of reply before we place the matter before at DC. And this is where also we have a bit of a problem. Legal practitioners are the ones who make up the investigating committees or disciplinary committees. We urge you to avail yourselves to be able to sit in these investigating committees and disciplinary committees, because if, for example, in the Eastern Cape, we have a panel of 100 of you who avail themselves, then we should be able to place as many matters as possible between a 2 or 3 member disciplinary committee, because we'll just choose from the pool of 100 of you. But we find that we don't have enough legal practitioners who are availing themselves to look at these complaints and to make recommendations and be able to close those matters. The Act requires that it's you legal practitioners. We are almost a self-regulator because you make the recommendation based on the information that is placed before you. And maybe also in closing, the 9 provinces, provincial councils term is ending in March 2022. The elections for the 9 provincial councils are going to open in January 2022. They will be online. I urge legal practitioners to avail themselves to serve on the provincial councils so that we have as much people for the wider profession to choose from. You are urged to stand up and serve the profession in the upcoming provincial council elections. Thank you.
Thank you so much, Ms. Nzuza, for that very informative and an interesting input that you've provided to us. It's very clear, comrades, that the work of the Legal Practice Council cannot be achieved alone. And that is why it's important for us to be having these conversations with the LPC, because all of you are on the ground, so you know what the issues and the problems are. So if you have any questions, I'm going to open up the floor now so that we can have our questions. I'll recognize in order. 1, 2, 3, 4, 5. And could I ask comrades to please use the microphone over here? I don't think we have a walk-in mic, do we? Okay, I'm recognizing one who's taken the platform, and then in the
Always.
sequence that I have said.
Can you hear me, Chandra? Can you hear me? Can everybody hear me?
Just raise the mic, Comrade Raj.
Hi, is this better? Thank you, Chair. Chair, all of us here sitting in this hall, we're very passionate about legal education. And as you know, and as Comrade they will know, we also have a legal education arm of NADEL. And then there's a wider legal education arm, which is, and we're part of it, the LSSA, which is called LEAD, which is Legal Education and Development. Now, what has happened over the past few years, the funding to legal education and development arm of the LSSA has been curbed. And the position is, what happens is that LEAD puts a funding proposal to the LPC. That funding proposal, if I understand it correctly, then goes to the Fidelity Fund, who approves it as part of a wider budget, comes back to the LPC, and the LPC then cuts our budget. And this is really hampering access to legal education. And everybody talks about the Fidelity Fund certificate and getting your audit books, etc. One of the best ways to ensure that you have good lawyers who can practice properly is to educate them. And I'd like to know from the members sitting here, and especially the members who are part of the establishment of the LPC and the EXCO, and thank God Janine, who was part of the SCLE at one stage, and we know that well. What are they going to do in future to ensure that the money that is allocated and should be ring-fenced for legal education? Because if we don't do that, and sorry, just to digress slightly, not actually a digression, the LPC has virtually outsourced its function of legal education to the LSSA. And by not giving the LSSA the funding that they require, they're really curtailing that object. So I'd like some answers and also appeal to the LPC to ensure that we get funding. Thank you.
Thank you. Okay, the other. Are comrades going to come to the mic, or can I have somebody to assist maybe with to make it a walk-in mic?
Thank you.
You're going to come to the mic? Okay.
No, I do have a question as well.
Okay.
Oh, it's Kanya Kenga from,
And now, comrade, just were you on that side?
yeah, I was on that side.
Okay, Krish.
No, it's Kanya Kenga,
Just take 5 and then you answer.
Comrade Kanya Kenga from Tata branch.
I can't hear him.
I've got few clarities that
Comrade, can you just raise to the mic?
All right. Am I louder now? No, it's Kanya Kenga from Tata branch. I've got few clarity questions that I would like to seek from the LPC. The first one would be, you'd understand that the Legal Practice Act provides for candidate attorneys to either have 2 years of legal training experience or 1 year, provided that they've attended law school. Those that have attended law school that, according to the Legal Practice Act, should serve either 1 year, according to their choice. So I wanted to ask, there's this notion in the Legal Practice Act where they say they would either be able to appear in the regional court after having served 2 years of their articles. First year in the district court, second year in the regional court. So what does the Act provide in terms of the gray area where those that are from law school go into their legal practice contract? How does the LPC provide for those that are only able to serve 1 year?
Okay.
How does it provide for them? Secondary to that, did you capture my question? Okay. Secondary to that, I would like to also inquire with the LPC that there's also this aspect where a person who has served 2 years or 1 year and has completed their contract, in terms of the right of appearance, to appear in any court in the Republic. Once they've completed their contract, automatically their right of appearance expires. So I would like to know is there any provision that the LPC makes for those that are in the process of either they are in the process of writing their examinations or have completed or are in the process of applying, making their application for admission in the High Court, whether they would be able to appear in the district court or in the regional court for having that right of appearance,
Okay.
whether there's an extension. My last question, Chair. I think I'm done. Okay.
Got
Thank
it.
you.
Thank you, comrade. Yeah.
Yeah, got it.
Okay. Comrade Krish was next. I'm going to take the two, and then we answer, then we'll take another set of questions, okay?
Thank you, Chairperson. And
Comrade Krish, can you just raise the microphone?
Yeah.
I'm shocked that my ex-councillor is asking me, my ex-boss.
We have to be very COVID conscious, please, everyone. I get worried what's going to happen after this weekend. But, Charity, I'm with you here, so
Okay.
it's not you.
All right.
I worked for you for 3 years on the council as an LPC member, and I'm glad it ended at the end of November. But I want to put on record, you're one of the hardest working persons, and you go to more than extra miles.
Thank you.
I hope your health will stay strong. And the problems you face are the problems that we've inherited nationally. So what I've got to say, I just hope you, and Janine is here, she's got to take a lot of responsibilities. And many of the problems that have been coming through now are the problems of the profession to help you to fix. You can't fix it up as the EO.
Yes.
You are a regulatory body, but the lawyers here in Nadel, they are a powerful force. They are in branches everywhere. They are linked to all the PCs. And the question that my comrade just put to you earlier is so easy to fix up. It's about just tinkering with regulations, making access to the profession, access to justice, what is embodied in the Act, meaningful. And it's easy. It requires will and efficiency in the council, which I must say I didn't find as much as it should have been. So the two issues I want to address, which I think can do a lot. One is the money. Everything you're suffering with, Charity, is about budgets.
Yes.
You have a 330 million budget for a year to run the LPC and the PCs, everything. And it's still you're short. Plus, lawyers are not paying subscriptions. Many lawyers don't have Fidelity Fund certificates and they're practicing, and there's a whole lot of issues. The fundamental bottom line here, the Act is to protect the public, not the lawyers. This is the new dimension. And our chairperson made this important statement that the work of the LPC cannot just be achieved alone by you and the council. That, to me, is where does the power lie? It lies in the legal profession. You are just a regulatory body with official salaried people who run the council and the provinces. So to get the money, you need to be creative. I don't want to repeat what I said yesterday. There are ways in which you can get the money out of the wealthy practitioners to subsidize the weaker and the poorer ones who are being struck off because the profession is not easy to survive in. But you need so much of money to have more disciplinary committees, which is the reverse. We're fixing up the damage that we should have prevented. This is what the minister didn't want to, well, he didn't have a chance to hear us say this. You fix up the problems at the bottom so that whatever comes out will be cleaner and less contaminated. So the money aspects, I'm not going to go into detail. I even wrote a whole article which was published and nobody bothers about it in the LPC. Now, I also served on Education Committee, Rules, Ethics and Policy Committee, which I chaired, and one other committee. I lose track. But the power of getting the LPC to be fully and operational, and I'm dealing now with governance. Section 23 of the Act talks about the provincial councils. And Section 23 has got about 21 duties under Regulation 5(2). I'm mentioning these things, lawyers, please, comrade, look at these things, because we can help the LPC be effective. And the LPC, under the old LPC where I was, rejected the provincial councils. I want to put it as crudely as that. The lawyers, not the staff, not the directors, but they placed the weight of the control in 9 provinces in the hands of salaried staff. The provincial councils, with all our top lawyers sitting on them, were rendered impotent. We even had one head of a council from KZN, Asif Essa, who battled, came there. He was humiliated in the LPC meetings. It's all taped, recorded. I've got transcripts. Everyone has got it. We were made to be seen, those of us in the council who supported a grassroots, I don't want to use the word revolutionary. It's an ABC, it's a fundamental principle. Your power comes from the grassroots. Every lawyer, all of us here, who do they have a link to? It is to the province, not to the LPC, which is an overriding council. Charity, this is for Janine to answer. We need,
I don't want to cut you
yes,
short.
so I'm appealing to all of us as comrades to ensure that our lawyers who sit on the councils are given a seat at the LPC meetings, at least one of them from the council, so they know what the problems are on the top, how they can fix it up on the bottom. And so those of us who are like me, an ordinary practitioner in KZN, can pick up the phone and not look for a salaried staff, but I can phone my councillor and say, listen, what is going on here? The councillor will not say to me, I don't know, because I don't know what's going on at the LPC council. There's a lot more to be said, but I'll stop here. I'm sure everyone will be happy on the council that I did. Thank you.
Thank you. Okay, I'll take one more question and then we'll do answers. We were standing. I'll take you in the next round. Oh, you're going to give it over? I did recognize a comrade. Okay, let's do one more. We can, comrades, the two of you can resolve it and then we'll do answers. And then we can just do another session and then we can wrap up.
Thank you. Thank you, Menzuza, for making time. Thank you, Member Heiberg. I serve on the...
Comrade, your mic.
Oh, sorry. I serve on the Free State PC, seated at Bloemfontein. I'm glad Krish touched on one of the issues that I was going to address, especially with the decision-making process. Yeah. Okay, thank you very much. I will not pound a dying horse, if you may call it that. So I just wanted the new dispensation to look at that, because we are not part of the decision-making. We are told of decisions, and even if it's just our chairs to sit in meetings so that we can deliberate and be able to serve and, properly serve. Thank you very much. And coming to serving on committees, the real issue is about money. I know with most of the practitioners from Bloemfontein, I mean, Free State has just but a few practitioners. They don't want to be sitting in a whole day session for just 2.5. I know money is a big issue for them, especially when we don't have big cases that we make money out of. I mean, we have to spend at least a day preparing for a meeting that will be seated on the next day. So I know from a lot of practitioners that the honoraria issue is a big issue. They would want to serve. It's not all about the money. Thank you very much.
Okay. Thank you. I'm going to close this one just for answers and then we'll open it up again.
Thank you, legal practitioners. The issue on the first question about funding of legal education really is dependent on the availability of funds to council. And as I said earlier, our source of funding is largely what we get as an appropriation from the Fidelity Fund, and coupled with the subscriptions that we collect from LPs. You'll know that our services, like good standings, we charge a very minimal amount. We try and not burden you with those with high fees. Our exam fees are quite low, so we don't even count those fees that we receive for the services as income, because they are quite minimal. But you will note that the Fidelity Fund in the past 3 years has reduced our funding by over 20%, and that culminates to us cutting down on our costs and also having to reduce what we appropriate to legal education service providers. Again, and I reiterate that we have a big problem where legal practitioners are not paying for their subscriptions. And that is another source of funding that could go towards funding legal education. I think the gentleman spoke about the outsourcing of legal education. We think it's the best model to outsource legal education, because then we can get the best people providing legal education. It's not only the elite who we outsource. We outsource the bars are doing legal education for us. All the GCP bars, the Pabasa bars. There's a few, Nadel provides some of the education and we fund them. We've got BLA who provides child advocacy training, Pabasa. So there's a whole host of service providers that provide legal education. And it works well, except that if we had unlimited funds, we will fund them fully as much as we can. But we are told, for example, at the Fidelity Fund, that the number of misappropriation of funds that they have to deal with and where they have to reimburse clients is one of the reasons why they have to cut our funding year in, year out. So that is just a balancing act that we have to work with every year to ensure that we are still able to provide the service of regulation and we are still able to provide, to appropriate money to service, to legal education service providers. But you will note that, again, with the issue of the PLT, because I know that this is one of the main issues where the cost of that 6 months training is 17.5. Most of the candidates are forced to go through that training because you as legal practitioners are not giving them a chance by taking them as candidate attorneys and training them. And again, this is where the legal profession needs to work with us. Engage legal candidates so that they can get training internally within your own law firms, and then they only do the 400 notional hours, which is much cheaper than the 6 months training program. So it's not compulsory to do that 6 months. The compulsory training is the 400 notional hours only, which is, I think, not less than 5,000. I stand to be corrected. So we must just weigh, because our focus is for a candidate to actually receive practical training in your law firm and then doing the 400 notional hours. So we are not going, obviously, to put a lot of money in the 6 months program, because that is just an additional training that you can get for yourself, but it's not a requirement for you to be admitted as an attorney. And again, when you do that 6 months, you must apply. So it's not automatic that when you've done the 6 months, you automatically get your articles cut by 12 months. You must apply, and your principal must ensure to us that they've given you all the training that is required as per Regulation 6. I think I've answered that question. I'd like Alfred to just answer on the 2 questions on appearance, right of appearance in the regional court, and the expiry of the right of appearance after the end of the PBT contract.
Thank you, EO, Comrade President, esteemed justices, colleagues and comrades, good morning. Just to answer the question which was asked by the comrade from Tata Branch about the extent of right of appearance that is issued by the provincial offices in terms of the Act, Legal Practice Act, by the provincial offices. The response or the clarity which I wish to provide is as follows. Remember that candidates can either enter into a contract of practical vocational training for a period of 2 years, as you have correctly pointed out, comrade. And immediately on registration of the contract, then you are issued with a certificate of right of appearance in the district court. And after completion of 1 year, 12 months, then you apply again to be issued with a certificate to appear in the regional court. In order to enter into a contract for a period of 12 months, which is 1 year, you need to have completed the structured coursework program of not less than 400 notional hours. And then the period of contract will be 1 year. Then the certificate that will be issued is only one certificate for that period, which allows a candidate legal practitioner to appear only in the regional court for the duration of the contract. And in respect of the other issue that has been raised, I think I'm very grateful that it has been raised because it's one of the problematic issues. Once the validity of the right of appearance has expired, it means that the principals or the candidate attorneys can no longer appear in court, and that they can no longer continue doing all the work that they did as candidate legal practitioners. Because remember, once the contract of practical vocational training has expired, then you are no longer a candidate legal practitioner. You may remain in the office of the principal, but in a different administrative capacity, performing administrative duties, but you may not continue to appear in court until such time that you are admitted to practice as a legal practitioner. Continuing to appear without the right of appearance is a form of misconduct. We have had several matters of that nature which have been referred to us by the courts for investigations, and we are dealing with them. And to come to the second question as to what can be done to allow those who have not yet completed the examinations. At this stage, there is no empowering provision in the Legal Practice Act. There was such a provision in the Attorneys Act, which has now been repealed by the Legal Practice Act, which allowed the extension of the certificate of right of appearance for a period of 6 months, for as long as the candidate, is going to remain under the employ of the same principal. At present, there is no such a provision. The Council has received such request and motivation. I can confirm that an amendment to the legislation to have that provision has been made to the Justice Department. We are hoping that it is going to be supported and that the Act will be amended to cater for that. So in due course, so until then, there are no extension. The right certificate of right of appearance of candidate attorneys cannot be extended because we don't have the power to do so. But as I've indicated, we are certain that in due course it will be addressed. I hope that I've addressed all the issues, but whilst I'm on the floor through you, Madam Chair, let me just comment on one issue which my EO has raised about assisting us to allow LLB graduates to access the profession. We as directors in the provinces, because in order to be admitted, you need to have passed competency-based examinations. So what usually happens is that sometimes we receive complaints from the candidate legal practitioners saying that their principals are not allowing them to go and sit for the examinations, which means that if they don't write those examinations, then they will never access the profession. So we appeal to the legal practitioners who are candidate legal practitioners to please support the candidates' attorneys, to give them sufficient time to prepare for these examinations so that they can pass, so that they can access the profession. Because the LPC alone, while that is its objective, I think it requires the involvement of all of us, including the candidate legal practitioners who are eligible to take on legal candidate legal practitioners. And the other issue, through you, Madam Chair, I think it is important that I should address it. I think Comrade Tia raised it yesterday. It is a valid point. The prohibitive cost of attending this compulsory structured coursework program of not less than 400 hours or 150. I'm sure that we have taken a note of that. I'm sure that is something that the LPC will be engaging with its legal education service providers to see how those costs can be limited. Thank you so much.
Thank you. And then my council member in the Free State raised the issue of the honorarium. I'm not sure if you are aware that there is a proposal before the new council to review those rates, especially for 2022, because we are aware that the work that we require from you as legal practitioners, whether to serve in our ICs or DCs, is demanding. And it's up to the council members who are sitting here today to maybe give direction. I have raised it with them, and it should be reviewed indefinitely from January 2022. But I think the chair will respond.
I've been told I must only be 2 minutes, so I'll be very quick. I first want to say thank you very much to Charity and Alfred. They were quite eloquent and put our position forward. What I can see clearly from today is that the LPC needs more roadshows. We need to interact with the practitioners more so that we can understand the problems and we can explain to you our challenges. One of our main problems is the funding. We are dependent from the fund. I have a rather large friend who is a lecturer at the law school, and when their hours were cut, she rather aggressively attacked me. And there's literally nothing we can do unless we have the funding. If you're not educated, you can't be a proper attorney. So we agree that education is paramount. It's also not necessarily that we are outsourcing, we are accrediting much more organizations. We've set the terms and norms and standards. We rigorously have oversight. So training is of paramount importance. It's part of our mandate to ensure that we have access and we transform the profession. But we are dependent on your cooperation, first of all, for you to pay your subscriptions, and secondly, to take on the candidate attorneys. Charity raised this at our council meeting we had last Saturday, and to her credit, we are going to look at reviewing what we are paying the people that's serving in the IC and the DC. We have got a strategic session set for the end of January, so that will be addressed, and the Finance Committee that has been established last week will also look at it. It was something that it's very close to my heart, which Krish has raised, that the PCs must be involved. We are going to have a look at how we can structure it in our strat session, that either they should attend virtually, the chairs, or they should at a minimum attend once a quarter, more if we can. But once again, we are limited by the funds. But I agree completely, as the LPC, we won't know what's cooking literally if we don't know what's going on in the ground. So it is important for us to have more sessions like this, and it's important for us to have a closer relationship with the PCs, and it's important for you to work together with us, to tell us what the problems are. We're not necessarily always going to agree on the issue, but at least that we can open the communication channels. I think I've answered the remainder. Thanks.
Thank you very much. I think I must also thank the DSG and the CEO of the LPC and Mr. Rana. Thank you very much. We highly appreciate it. We are enlightened about the LPC. I think this will conclude this session now, and then we move to the next session. What are you talking about? No. Unfortunately, no. Like, what is going to happen now is that at 1:30, we have been booked. One of this branch of Natal have booked us for lunch, else we're not here. All of us will have to move there. We will have the cars parked up, in front of the hotel. And those of us who have cars will assist, but they will take us to the place. Our lunch is booked there. Very nice. I will not have that lunch. Special for us, for special people. So please don't disappoint us. We must be there. Secondly, we are going to finish that financial report. What's this? We are going to have the financial reporting now, investments and so forth. And after that, we have resolutions and we go. But Justice Madlanga would have made a mistake. We have in 2018, when we went to Venezuela during the elections, we were given an invitation by the president of that country, President Maduro. And one of the things was to come and have a mission, to have a better understanding of their own system. We were to go there with a delegation, and we're going to ask some of you, the judges of Natal, because our team, not that we are in South Africa, but for purpose of Natal, but we wanted people in the justice, the judges, Natal and Senior Congress, just to understand the broader, their legal system, judicial system, so that we have an informed position. That process, because of COVID and some other things, and we have strengthened up the position of our international relations. There's some vote now, specifically, we must ensure that that is successful. We have a Minister of International Relations in Natal for the first time. He has nice suits. Very, very well dressed every time. Even now, he is the only one with suit and a tie. Can you stand up, sir? Mr. Tia there. Yeah, that is our minister. that is our Minister of Foreign Affairs. Yeah. So you will fast track this because we would like to complete that mission, because that country is for the first time when you go to these countries, even in Cuba itself, where you only not meet with the party, but you meet with the government. And the president of that country had a session. We discussed the challenges there, and we took up the matter even at the, what you call, I forget this. But the meeting of lawyers, international, I mean that conference where there's everyone there, what's this? Yeah. The International Bar Association. We raised the issue, and then there were others who said, no, you don't understand, the situation is complex. But I want to say, I said, please give me your complexity of the situation, because I know this one. And then he started to say, I said, you are from that country. He said, no, I'm from America. I said, once you are from America, I'm talking about something from the Peruvian Republic, there's a problem already. But we want to understand it ourselves. And then when we say we support or we endorse this, is what we understand. The second country that were in China, the Law Society, the minister of the Law Society or somebody in the ministry is the one that leads the Law Society. It's not just anyone. And when you talk about human rights, be careful about your language of human rights. And then when you come from perspective of South Africa, there was a debate, I think in the BRICS countries, until we came and said, look, the definition of human rights, which is what one day, even at NADEL, we have to broaden and understand, is not the same as we understand. And therefore, it's very important when we go to this, and Mr. Tia here must ensure that this is happening. And we will make sure that that department is empowered, and he must understand all the machinery that we need. So I'm telling you, Justice, because we are not there when we're electing, and then you must understand some of these things. Thank you very much. So we will break for, we will not break, delegates will not break. We'll just go straight to finances. We'll just excuse other observing delegates. But they mustn't go far, because at 1:30 we are having a lunch together, come back, freshen up, and then later we have the gala dinner. The conference is towards its end now. Yes, so we'll only excuse the non-voting delegates and remain with the voting delegates, because we are doing finance and the resolution. So we are not even breaking for tea, please, because the time is already, So we will ask Madiba in the meantime, strike Madiba. We are requesting this comrade, strike Madiba. We are requesting Mr. Mahlangu and the current Minister of Finance, who was the deputy in that administration. We have our Minister of Finance here. Iphi mali yethu. What does the EFF say, and what was that slogan? Pay back the money. Oh, yeah. You see, when you have the issue of money, So, we are going to, comrades, I don't even want us to have introductions and what. We go straight to this session. We start with the issue, of finances. One, you have been given the financial report. You do have. Every report was given. I was there. It was sent to branches, so we do have. What we want from you, Madiba, because I know, even in court, people have a tendency, if you have prepared heads of argument, they are 57 pages. Even when judges say, we have read your paper, somebody will go on and submit. All what at this stage we want is the executive summary of these reports. We don't want detailed report. It's there. And if we have questions, we'll ask for questions. We want you to get on the key aspect. And from you, Mr. Mahlangu, we are requesting you to deal with the key aspect. And if you have proposal on the investment, on how we do, make that that submission. What proposal do you want? Then the conference will deal with that. Over to you, Mr. Ntuli.
Good morning, colleagues, comrades. Treasury wants to assure you that there's no need to come with slogans to say pay back the money is in the kitty. Yes. Thank you for the opportunity to present our financials. From the onset, would like to profusely apologize to the membership for the delayed distribution of the finances. This was as a result of one of the personnel who was dealing with our finances at our auditors resigning. We submitted our financials timelessly. She resigned, and another person was then requested to deal with our finances. But this person who resigned has been dealing with our books for the past 3, 4, 5 years. So it was difficult for another person to come in. What we then did, realizing that we are now running out of time to get our books ready, we then, with the assistance of the SG, tracked down the personnel that was employed at the Morar auditors and requested her to please assist in finalizing our books and resubmitting them for audit. She complied, she did that, and then they were sent to our auditors. What was given to you, realize, obviously awaits your consideration and either queries or submissions, which will thereafter be taken back to the auditors for signing off. That is why you did receive the books. I mean, yes, the audited statements a bit late than expected. That is the position. We once more apologize for that delay. At least now we have a version of our audit from the auditors that needs our attention. I'm going to request the members to, if there are some queries, we'll definitely, or submission, note them out, and then we'll definitely take them again to our auditor for finality. The financials to be presented covers the period from the end of 2019 and the end of December 2020. It is our responsibility as the NEC and the membership to ensure that the annual financial statements fairly represent the state of affairs of the organization as at the end of each year in question. It is also required from us to maintain adequate accounting records, and the NEC or the membership is once more responsible for content and integrity of the financial statements related as presented by the Treasury. Then there comes in the external auditors who are responsible to independently audit and report on our financials. That is the process we undertook. Our current financial position, starting from the income part of it, Nadel owned 10% from Tawe Mpumelelo Investment, which was a BE transaction between Nedbank, Old Mutual and Federal. That is a BE transaction in 2015. The values, when it went up, the values therefore realized were awarded to Nadel and other stakeholders. Nadel got the sum of 45 million. Comrades, we have a very limited sources of income for our organization. We only get the sources of income emanate from subscriptions, the annual grants from the LPC, and then obviously the Old Mutual payout that we had. The challenge we are now facing, comrades, is that there has been a cut of contributions, say, from the LPC, in the past, we were awarded 2.1 million quarterly for our training staff. Now it has been reduced to 500,000. Before the new dispensation, at least we used to get contributions from the previous 4 law societies who annually contributed to our AGMs and stuff, including the LPF or LPPF. Expenses that are incurred on behalf of the organizations are administrative costs, that is our bank charges, IT support, and subscription and to affiliated bodies. We are aware that we are affiliated to some bodies like you are Pavasa and so. And the governance costs, that is our NEC and executive meetings and our annual general meeting, for sure. We should also reflect on the sustainability of our income going forward. Comrades, it is time now to seriously exploit various strategies and methods that will ensure that our organization achieves sustainability in relation to its income. As mentioned, we have those sources as sources of our income. Comrades, we should also look at that issue seriously, because what happens now is after the limited contributions we are having, we are forced to dig deep into other financial resources of the organization to fund some activities of the organizations. One has in mind the membership subscriptions. This issue, comrades, needs to be relooked into seriously, that is regarding the payment of subscriptions. It would seem that the recruitment drive of membership usually manifests itself greatly during the election year. The tendency is that the branches will only collect and submit subscription fees only during election year, so as to be regarded, in my view, to be members in good standing. Surely this practice aims to achieve other issues which we need to clamp down. Treasury is of the view that the collective membership should consider how to deal with a situation where some members will be in arrears for non-elective years without any consequences. Some branches, as of on Thursday, were still hustling and struggling to pay their subscriptions. That is during this conference, which is totally unacceptable. The other concern, Your Worship, that goes into our expenses is the concern raised or discovered by Treasury that workshops and other training courses are offered by these organizations to our members to empower them. But sadly, despite these members having confirmed their attendance, there will be no shows in those workshops and so on, resulting in wasteful expenditure. Treasury therefore proposes that those members who confirmed and failed to attend should be held liable for the full cost of the individual member who was booked in. It is also coming to one of the sources, our annual general meetings. It is quite clear and worrisome that our financial expenditure on our annual general meeting is escalating astronomically year after year. We as Treasury, we are not oblivious to the state of our economic and financial constraints challenging our members at large. But however, I'm going to indicate a scenario here on this escalation of our AGM cost. In 2018, the cost incurred for our AGM was 1.48043, so say 1.4 million. The following year, 2019, that amount escalated to the sum of 4.2 million. this year, 2020, unfortunately, after paying some deposits of about 1.3 million, we couldn't proceed with our conference. And then this year, there is going to be additions on the 1.3 already incurred for this present AGM. We therefore, as Treasury, urge membership to come with innovative ideas and suggestions to curb this downtrend that will have a negative effect on sustainability of organizational going forward. We have this human rights funding, which I alluded to before. This vehicle, if one looks carefully now and then, if we are in financial constraints, a donation will be made to the organizations to try and assist us in it. Mr. Matlangu will deal with this investment of our human rights from Old Mutual funding.